Hi, what's your name, sir?
William Collins.
All right, Mr. Collins, you've got some traffic matters first, which we've got to deal with before we call your main matter. It's a traffic matter. It's 2 U tickets in which you failed to appear in court for, sir. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside those arrest warrants. You have a personal bond with no dollar amount in these matters. In these misdemeanor matters, it carries a maximum penalty up to 93 days in jail and/or a $500 fine. You have the right to remain silent. Anything? I'm sorry, Ms. Kirkland. Okay.
My apologies.
You have the right. Okay, you have a right to remain silent. Anything you say can be used against you. You have a right to an attorney. If you can't afford an attorney, one will be appointed on your behalf. The tickets are U660-42623, May 26, 2023. Basically, disorderly conduct, jumping on and off the bus and refusing to allow the bus driver to drive the bus. U631-66122, March 10, 2022. Mr. Collins' dog was loose and attempted to attack officers. Ticket U660-44523, December 9, 2023, causing a public disturbance. On each of these 3 tickets, sir, you're going to personal bond, no dollar amount. Pretrial court date April 2nd in front of Judge Kenyatta Stanford Jones. Now to your main matter. Calling case number 240-559-8701. Pearson Michigan versus William Collins. Appearances, please.
Good afternoon. Lisa Coyle appearing on behalf of the people.
Good afternoon,
Your Honor. Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Collins, who has been advised of his rights, wishes to stand mute and waive the form of reading.
Court ordered not guilty plea on behalf of Mr. Collins. Argument. It looks like they stay in the same building with 2 different flats. Is that accurate?
That is correct, Your Honor.
Yeah.
Okay. All right. Go ahead, Mrs. Coyle.
Yes, Your Honor. The people in this matter are asking for a $50,000 cash tether house arrest. As of yesterday, 2/28, when this occurred, he was sentenced before the Honorable Miriam Bazzi in Third Circuit Court to 3 years probation for an arson prep to burn. So that very day that he was placed on probation, he then went out and committed this home invasion. I also see on that case, he had a capias back from February 14th of 24. His bond on that case was set at $50,000, 10% with the tether prior to him being sentenced. Your Honor, the people also believe he's a danger to the community, not only because this is his landlord and he kicked the door in and entered her home. Whether they were both highly intoxicated, it has nothing to do. It looks like from his sentencing, he was sentenced. I'm going to look at this. Make sure I kept it. He was sentenced to team wellness. So there tells me that there's probably an issue with mental health as well as possible substance abuse. And I can look back at his record starting from 2010. He had impaired a 2015 OWI-2, a 2014 impaired, 2016 OWI-3, 2016 domestic violence, 2016 domestic violence, assault and battery, 2017 domestic violence 3, felonious assault, MDP, 2017 MDP, felonious assault 3 counts, are resisting and obstructing, 2020 disorderly, and as of the 28th, a prep to burn. Your Honor, the people feel that not only he is a danger to the complainant, but he's a danger to the community. I'm asking for $50,000 tether house arrest based on his past record, based on what's been going on, and that the day he gets sentenced, he goes out and commits another home invasion. So I'm asking for that high cash bond, tether house arrest.
Just a question, was that arson related to this building in question? Or another building?
That I can go back and look, but if you want to go take that, I can look. But
Okay.
I did pull up his sentencing, Your Honor, and it does show that he was weekly attendance to team wellness, community service, 3 years probation. If not on a tether, he has to be on a tether. So I will look up at the arson.
All right, thank you. Ms. Kirkland?
Thank you, Your Honor. So it appears that the people are asking you to give him a bond based on everything else in his criminal record, and I didn't see much about the allegations here. So, Your Honor, I'm asking for a personal bond in this case, and I don't mind a personal bond in this case, given the allegations in this case. As Your Honor stated at the beginning, this is a two-family flat, which the landlord lives at the bottom, and Mr. Collins lives at the top. Mr. Collins was in the home. They were both highly intoxicated in the officer's words, so I don't know if they were drinking together. At some point, she wanted him to leave. He walks out while the officers are there. And the allegation, even though he disputes, how the door got open, but the allegation is that he then says, watch this, and just pushes the door open. This is not him walking into some random home and invading a home. This is not him invading someone's home that he does not know. This is not him even entering into someone else's home. The allegations that he is being petty and that he pushed the door open, even though Mr. Collins even disputes those allegations. So, Your Honor, I am asking for a personal bond in this case. I'm asking that you give him a bond consistent with not just the charges in this case, but the allegations in this case, that this is a home that he lives in where his door is right next to this door. He does live upstairs. Am I talking too fast? Yes.
Ms. Kirkland, I have a great deal of respect for you. You talk fast, I listen slow.
I understand. I will slow down.
I got it all.
Okay.
I got the gist of your argument, and you argue very, very well. I have at least one question for you. Does your client have alternative place to stay?
Mr. Collins, can you find somewhere else to stay if the court, is only willing to release you if you're able to find somewhere else to stay? Are you able to find somewhere else to stay?
Yes.
Yes, Your Honor.
Where? Well, I should not necessarily where. With whom?
This will be with my older brother.
Okay. Does he live in the area?
No, not in the area. He live in a whole nother city.
What city?
What city, sir?
New Haven.
New Haven, what? Michigan? Connecticut?
No, Michigan.
How far is that from here?
I would say about 30 minutes away if you use the expressway.
What other way would I go? I don't know.
Normally, I would take the expressway, but I would take grass straight out and then run straight.
No. Don't worry about it. Just give me one moment. I'm gonna find out myself.
Hey Siri, how far is New Haven from Detroit?
It's 43 minutes, 36 miles.
Michigan.
All right. Okay. All right. Anything else, Ms. Kirkland? At a slower, more measured pace?
I understand. Yes, Your Honor. I just wanted to state that he is a lifelong resident and have strong ties to the community. As you stated, he can stay with his brother. So we are asking for a personal bond in this case, and that you give him a bond consistent with this case and this case only.
All right, Mrs. Coyle.
I found your answer. And also, when you make your bond recommendation, Your Honor, he is under sentence now to be attending team wellness. So that is something he has to do. So But this occurred,
Yes.
arson prep to burn occurred in August 25th of 23. It looks like it is a Sunoco station that he's already pled to it. So it says that the defendant opened court some motor oil he took from the shelf, poured it all over the location, grabbed a candle, and attempted to ignite the motor oil he poured on the floor.
Judge,
Okay. So
That he
okay.
pled guilty. He has
No.
pled guilty.
No. I got it. Last question. Was he out on bond when he committed this offense, allegedly?
He was sentenced that day. Yes.
So he was
not
on
on bond. He's on
bond.
probation. He's not on bond. He's on probation when he committed this. The same day he was sentenced, he went.
Gotcha.
Okay.
Gotcha. And what was the dollar amount again, Mrs. Coyle?
I'm
You're
asking
requesting?
for 50,000 cash because his arson prep to burn.
I got it. Mrs. Coyle, I got it. Ms. Kirkland, I got it. All right, court having heard argument as to bond, given the fact that he was just sentenced the day of this alleged incident, the court's going to adopt the recommendation of the people, $50,000 cash, so surety, GPS tether. Unfortunately, it will have to be at the house on Maple Ridge. It doesn't look like if he's tethered to the home, his brother's house in New Haven, he's going to make his requirements for his sentence. But I'll put a GPS tether curfew, 9 p.m. to 6 a.m. curfew. No contact with Teresa Johnson. I know that's your landlord, but you pay your rent, slide underneath the door, whatever, no contact. I know there's got to be, let me put it like this, no assaultive contact. I know that's your landlord.
Now, Judge, Your Honor, can I address the court?
Are you sure you want to do that?
Mr. Collins, if I may, I am going to advise that you not make any statements. It sounds like Judge has made his determination. You will get a right to a redetermination hearing within the next couple of days, where we'll go before the chief judge and we can try to argue bond again. But I don't want you to say anything because this is recorded. You have prosecutors in the room. I don't want you to say anything that's going to hurt you.
Oh, no. I wanted to address two areas. The first, I was just saying, you ordered the bond that was $50,000 cash, but
Yes.
Right now I have two underlying medical conditions that I have been treated for, which my sentence that I got sentenced on the 28th was to house arrest with the $50,000 personal bond, just for me to go to court related things and my medical thing where I had
Sir, I'm a $50,000 cash bond, no contact, no assaultive contact with Teresa Johnson. I want to fit you with a GPS tether, 9 p.m. to 6 a.m. So that should allow you for any doctor's appointments or any other court obligations you have. Bond redetermination hearing Monday, March 4th, 9 a.m. in front of Chief Judge McConaughey. And also another condition of bond, no alcohol, no drinking, okay?
Okay, and then the second thing
any questions regarding your bond conditions and or court dates? Wait a minute. Probable cause March 12th, preliminary examination March 18th. Any questions regarding your bond and or court date, sir?
Yeah, starting, would it be in my right if I exercise under the Sixth Amendment going forward?
Sixth Amendment what?
To represent myself.
That is your prerogative. Have a good day, sir.
No, I said, can the report reflect that going forward?
Yes, sir.
Mr.
Have a good
Collins?
day.
Okay.
All right, thank you. William Marshall Collins II.
That's Mr. Collins. He's in pro per.
Calling case number 24055987001 of the state of Michigan versus William Collins II. Defendant is being charged with count 1, first-degree home invasion, habitual offender, fourth offense notice. Today's the date and time for bond redetermination.
Judge, good morning. Steve Vincent for the people.
Judge,
Collins, state your name.
William Marshall Collins II on behalf of the defense.
Okay. Mr. Reagan?
Judge, in arraignment, Mr. Collins requested at the arraignment that he wants to represent himself going forward. I just spoke with him in the breakout room just to reiterate, see if he wanted representation at this time, and he still wishes to represent himself in this matter. Is that correct, Mr.
Is that
Collins?
correct, Mr. Collins?
Yes.
And you do understand you have a right to counsel, and we have counsel here to represent you, but you want to represent yourself?
Yes.
Okay. Bond is currently $50,000. What is your argument for lowering the bond?
I went to the court due to the unusual circumstances of my medical condition prior to being incarcerated for the 5 days I've been incarcerated. I've been in the infirmary. I have an infection that's in my lungs that could spread through to the rest of my organs, which I did have a appointment set up for this Thursday to address that issue. Right now I'm on a CPAP machine, but my medical condition is deteriorating. And I was asking the court as I go forward in my court proceeding, as far as the court related, as filing motions or doing anything that can better prove myself in my defense, I would ask the court for the bond modification to stay the same, but change the cash to a personal with the house arrest, with the GPS tether, along with the other conditions that was set by the magistrate.
Okay. All right, Mr. Prosecutor.
Judge, as much as I appreciate defense counsel's alleged medical conditions, we do feel as though he's a clear and present danger, not only to this complaining witness, but to the community at large. The day of the incident was actually the day that he was sentenced on an arson case. And in that arson case, Judge, he tried to blow up a gas station. So he ends up getting sentenced on the day of this incident earlier in that morning, and then this incident takes place where he's kicking in doors to residences that he's not supposed to be at, that he's not invited to. One other thing, Judge, on top of the fact that he was literally on probation at the time of this offense for that arson case, this defendant has a substantial criminal background. Allegedly in that arson case, he was intoxicated. In this incident, there were signs that he was intoxicated, but this goes way back, Judge. 2010, he was getting convictions for impaired, 15 second offenses for being impaired, and 16 third offenses. And then we get into the assaultive part of the history. In 16, we have convictions for DV as well as an A and B. Then in 17, we get another DV. In 18, he's up to his DV third offense conviction. We have a felonious assault previously that he was convicted of, as well as 2 counts of R&O. And now we have a defendant who's on probation for allegedly attempting to try to blow up a gas station. And he's found kicking in people's doors, doing whatever it was that he was doing.
That's not the allegation here, Mr. Prosecutor, though. It's saying that there was an argument between him and his landlord, and the police were out there, and the police report states that while talking to the police, he stated, "Watch this," and he used his hands to push open the door.
But
So
Judge, with all due respect, that was after he ended up kicking.
that's all. I don't have that in police. That's not in the police report. I'm just going by what I don't.
That was the precipice that brought the police out there, was the fact that he ended up kicking in the landlord's door uninvited. That's what brought the police out, because the landlord called. And then when they ended up appearing, they ended up questioning him, and he says to them, look at this. And then he does it again. So I'm sorry, Judge.
No, I see it. Sir, where would you go to live if you are released?
I talked to the magistrate. I stay in the same house, but it's like a two-family flat. And
no, you can't go back. You can't go back there where the landlord is. So where do you have another place that you could go and reside, a family member, anyone else?
Oh yeah. Yes. Yes, I do.
Okay. Due to the defendant's medical condition, the court finds $50,000 on the cash bonds on affordable bond. Due to the medical condition, the court is going to allow a $50,000 personal bond with house arrest. He cannot, and no contact provision. He can only leave for medical appointments and court appearances. No contact with that address or the complaining witness. If he does not have an address that he can provide, he will not be able to get out until he can provide a place where he can be tethered to, other than where he was presently living.
Judge, may I ask for one other thing? And I hope you don't consider this
Go
a
ahead.
stretch. We've had a substantial amount of previous convictions for
no alcohol also. I'm sorry.
Okay.
And no alcohol and no unprescribed drugs.
I appreciate
that. Absolutely. Absolutely. All right. Thank you. Next case, please.